Josh Duggar was arrested, which had a significant negative impact on the Duggar family and businesses that show brands all these deals. After a thorough investigation, Josh is currently incarcerated in a timeout facility in Texas for individuals who commit crimes against the federal government and children. Only the daughters Jinger and Jill, who have authored books, have largely continued to profit from the Duggar brand since the Duggars were upended and cancelled. In contrast to Jill, who has authored 3 books and a children's book, Jinger released a book 2 weeks ago that isn't very good. However, there have been other fallouts involving the Duggar family name and any associated businesses in Arkansas that aren't always well received. Whether someone is related to the Duggars or not, or even speaks to them, sometimes even a loose connection, such as being a member of your extended family, can harm your business partnership. Amy Duggar and her husband Dillon King Dillon's restaurant Wellington, which was supposed to be a fine dining establishment with whiskey and stoys, apparently faced financial ruin when they opened a restaurant shortly after the pandemic struck and moved it from one location to another. When it first opened, it was in Rogers, in the same building where Amy's now-closed clothing company 3130 had a boutique. The launch was well known and famously remembered because Jill Duggar and Derek Dillard met up, went to Wellington, and enjoyed cocktails. It was a huge deal because this was the time when Jill was kind of letting the world know that she and her husband Derek drank, as if they actually had alcoholic beverages occasionally. Fairly positive reviews, and even though the location wasn't the best, it seemed to be thriving for the first few years. However, in April 2024, Wellington's abruptly announced that they were closing, and they never reopened. This closure coincided with a filing by their landlord, Hatcham Investments, alleging that the restaurant was behind on its rent. Hatcham Investments filed a lawsuit against Winston Holdings Wellingtons on April 2, 2024, as well as Dillon King. According to the lawsuit, Corey G. and Flint Boyce, the landlord at the time, claimed that they had an amended lease, which they had signed on March 4, 2022. A letter of default was mailed to them in January 2024, informing Wellington's owners, including Dillon, that they owed $82,613,150, and that they had 15 days under the lease to pay the full amount by January 24, 2024, in order to avoid further action. As a result, they were behind on their rent and had a ledger, which was in January, and according to a tenant ledger, they also failed to pay rent for January, February, and March of 2024. As a result, the landlord promptly filed a breach of contract lawsuit against them, claiming that they were unlawfully detaining the property because they had not left and lacked the necessary legal justification. This means that the tenant is still in possession of the property and unlawfully detains it without a valid reason or remedy for its payment defaults under the lease. The landlord has the right to issue a writ of possession, which gives them immediate possession of the property. They also have the right to a judgment against the tenants, so they were evicted essentially for failing to pay the lease. After the restaurant was closed for non-payment, they were left to deal with the judgment, which in this case totaled over $882,000. According to court documents, this led to 2 of his business partners filing for insolvency due to their inability to provide funds. Dillon's business partners Corey and Flint were removed from the judgment as defendants after filing notices of bankruptcy in October 2024. In November 2024, a consent judgment was filed stating that they had entered into an agreement between Dillon King and Hatcham Investments, which stated that the court had jurisdiction over the parties, and that the venue for this case was appropriate. Agreed that the plaintiff would be awarded $240,000 for breach of contract against the defendant Winston Holdings LLC. The parties also agreed that plaintiff Hatcham Investments would receive recoverable costs of $844.60 and reasonable attorney's fees of $1,982.50. The defendant must submit a verified schedule of assets that was signed by all parties involved in the case, and the judgment will accrue interest at a rate of 10% in November. Dillon admitted to breaking the terms of the agreement and entered into a separate settlement agreement with the landlord. As part of this settlement, Dillon agreed to pay $50,000 in certifiable funds in 2 installments, the first of which was due at the time the agreement was executed, and the second of which was due within 60 days. If they did not make the full installment payment as stipulated in the agreement, he would be charged interest and then he would be considered in default as well, and he would have to confess to the judgment in the lawsuit that the other partners signed in October. He would also have to pay $236,700, which is a significant amount. Dillon made the first payment, but he didn't pay the second, which led to another judgment being filed against him in January, claiming that he owed more than $200,000, and they were requesting a writ of garnishment. Based on the court filings, this occurred after some back and forth. The court issued a judgment after Mr. King Dillon requested that support be withdrawn. It now appears that a new order has been issued with the court's consent, which states that the parties to the case have reached an agreement between Hatham Investments and Dillon King, and that the documents filed on January 1st are hereby withdrawn. All of Dillon King's paperwork have been withdrawn, as has the plaintiff's writ of garnishment against Citizens Bank and Signature. In this case, the bank is hereby removed. The court's January 28th hearing has been cancelled, and it states that the parties agree that Dillon King has already paid the plaintiffs $25,000 twice against the outstanding judgment and settlement agreement. The parties also agree that Dillon King will pay the plaintiffs an additional $30,000 by cashier's check to Friday Eldridge and Clark LLP by March 23, 2025, if Dillon timely makes such a payment. The judgment against him personally will be considered satisfied if the parties do not take any further action. If Dillon King does not make the payment on time, they will file a motion with the court stating that he has failed to pay, and they agree that in that case, they will automatically be entitled to a judgment against him in the amount of $16,728. The parties sign the order, so he is released from paying the over $230,000. Unfortunately, two of his business partners have since filed for bankruptcy, which is just one of the legal issues Dillon is dealing with. In another lawsuit filed in January 2024, Dillon was ordered to pay more than $100,000, and the court issued a judgment on January 2nd. This lawsuit was filed by Hillcrest Holdings, and it was for their first location. They were initially at one location in Rogers, then they moved to another location, where they were sued for breach of contract. His partners attempted to use a series of complaints to escape paying rent, arguing that the landlord wasn't a good landlord, and that's why they didn't pay. Ultimately, a consent judgment was issued, stating that the plaintiff should receive a judgment against Dillon King in the amount of $16,999, which will accrue interest at a rate of 7.25% per year, as per the terms and agreements of the plaintiff and the separate defendant. Until paid in the fall, the two partners filed for bankruptcy, but Dillon King was ordered to prepare a schedule, verified by affidavit, and file it in the circuit clerk's office within 45 days of the consent judgment date. The schedule must describe all of Dillon King's property, both personal and real, including money, bank accounts, rights, and credits, and it must specify the specific property he claims is exempt under the law. He will have to sit for a deposition in February, and as part of the deposition, the landlords are requesting a lot of information about his finances. Basically, it's pretty crazy, including his business and personal tax information, statements of accounts and titles to vehicles, boats, trailers, and other assets. They are going to have to depose them and have them turn over all of their documents, which will be messy for them. Tractors as well as other things, documents proving ownership of any kind, including cryptocurrencies or NFTs, operating agreements by in-laws, articles of organization, as well as deeds to any real estate holdings and any stake in trusts of which he is a beneficiary or trustee, financial statements, loan applications, depreciation schedules, and other business paperwork for all the entities he owns a membership in. So I'm not sure if you're aware, but when Mary Duggar passed away, Dean received the real estate holdings of a few businesses and commercial properties that she owned. Later, those properties were given to Dillon and Amy, and for some reason, even though Mary had paid off all of the mortgages on these buildings, they took out a loan against them. They also made modifications to these commercial properties, and they currently have a mortgage out against these two commercial properties. Properties worth about $730 to $5,000 that are registered to an LLC in Dillon's name that the state of Arkansas revoked. The properties also have back taxes on them, and they are now in danger because Dillon has a judgment against him that was filed in Washington County for $15,000. In addition, he has another $30,000 that he needs to pay. It appears that what could have happened was that they acquired these properties when Mary passed away. Afterward, they might have mortgaged these assets to help finance their eatery. I'm not sure, and restaurants are among the riskiest businesses to start. To make matters worse, they opened during the pandemic, which is a dangerous time to start any kind of business, and they didn't have enough customers at that time. You have multiple locations, 2 contracts are broken, and the restaurant fails because it didn't. Being able to pay rent and in general, not being able to pay rent means that you don't have the money coming in from sales to support the rent that you're paying. This is a very unfortunate aspect of the restaurant industry, but restaurants fail a lot, so they risk losing a lot of money here. I know that when Josh, Dillon and Amy's situation went south, they told me that, I don't know, it was a couple of years ago that there was backlash in the community regarding the Duggar name and their businesses were suffering even though they had nothing to do with the Duggars. In my opinion, it was a total storm because they had a lot of stuff that was open while they still had a show and the Duggar fame, and when that collapses, you add a pandemic to it, and it just ends badly. I sincerely hope they manage to escape this situation and are able to either file for bankruptcy or pay off their bills. Unfortunately, the property they inherited is in danger of maybe being seized as part of this judgment for the landlords that they haven't paid. It's a mess, and I suppose the main point is why neither they nor he filed for bankruptcy. Perhaps it's because he didn't want to lose these other firms and he has other holdings. I'm not sure, but bankruptcy might have resolved some of these problems, and this is sort of the fallout. It's unfortunate because I think Dillon and Amy are good people who have always been very nice to me, but they owe a lot of money, and it's a risky business venture. It's more related to the Duggar collapse.